can't come up with something, then I think we're doomed for all of next year. So I appreciate all of you coming out in the weather. Some of you came from large distances to be here, but it shows the magnitude of this issue across our state. And we are absolutely here to try to find some type of resolution. Before we do start, I would like to know who all is represented. I sent out a few invitations. I do know that we have Chancery clerks here. Mr. Benson, are you here? Mr. Heyman's here for the Land Title Association. We have Mr. Bennett with the Bankers Association. I know that I saw Realtors. Realtors, are you wishing to speak? All right, Realtors is here. Circuit clerks. Yes, sir. We've got you. And then tax assessors. All right. So who else do we have that would like to speak or would like to be noted to be on the record? Anybody else? This is going to be Zoomed for those people who are not available to be here in person. It will also be live streamed in an effort to bring this conversation to everybody that's not available for the day. It's important for us to just talk about off the top. All right, we got somebody chiming in there. I can't see who that is, but welcome. Off the top, we want to talk about the issues we want to raise today. Number one, I think one of the issues is the notice provision on the collection. Come on in, Chairman. Chairman Wiggins. The notice provision on the collection of the liens. I think that is an issue. And number two is the fact that we do have garbage liens and the collectability of those liens. So that's where we're headed with it. I don't want to chase rabbits today. I promise you I don't. I don't think anybody here wants to with the weather as it is outside, but we do want to have a good conversation and hopefully we can come up with some idea where we're at. More about the problem at hand. If you don't know, or if you're watching this for the first time, we do have a problem with collection of garbage liens across our state. Here is currently pulling data from several counties across the state on my request to know where we're standing, what counties do it, which way, and which ones have registries of those liens. From there, we're just looking for the solution. Chairman, do you have anything else to add to that before we start? Vice Chair? All right. As such, well, let's just start outright. I'm going to call Land and Title first, Mr. Haymans. I'm going to call you first to talk, and please have a seat over here and please use the microphone. We're going to have a quick, and I would prefer 5 to 10 minutes at most from each person that's going to talk. And then after that, I'd like to have a civil discussion as to where we're headed with this. So, Mr. Haymans, I'm going to open the floor to you first.
Thank you, Senator McCollum. My name is George Haymans. I've been a practicing attorney in North Mississippi for approximately 18 years. Dominant work in the north part of the state, but we do statewide loan closings and title services. This issue has been one of my personal pet issues for 5 or 6 years. And when LTAMS was created, became part of the legislative committee and found that this is not an issue for everybody, but it's a big issue for some. And if you happen to practice in a county where garbage liens are inappropriately enforced or collected against BFPs, you can realize quite the embarrassment it creates for those involved, whether it be the realtors, the bankers, the buyer or the seller, and obviously all fingers point to the closing attorney who somehow missed a lien that was not even filed on record. So,
you're talking about a bona fide purchaser, your BFP.
BFP, that's right. I was sitting in the car this morning. It was pouring down rain. And I didn't want to get out, and I was just thinking, I don't even want to get out of the car to talk about garbage liens. But there's folks out there collecting garbage right now, and it made me real glad to have those folks out there that are doing that and that are collecting those. Just made me aware of how I didn't want to walk 100 yards. Somebody's sitting on the back of a truck right now. And this may not seem like a big issue to some, but it is an issue that we need to resolve. It's kind of like a split decision. in the appellate courts. You guys are the Supreme Court. We've got to get everybody working together and cooperating and following the same system statewide. So I appreciate your efforts. LTAMS realizes that some counties treat these differently, and that we've identified problem counties throughout the state. We've got some anecdotal information. If you'd like to hear that, put it on the record to be aware of it. We've provided several different versions of solutions, but we are open to anything that provides constructive notice or actual notice to the parties involved, so that these quote liens can be established prior to or at closing and not afterwards. The biggest issue we see is when a bona fide purchaser, third party, comes in, relies on an attorney or an abstractor to purchase a property, and then they're denied a card tag 6 months, 6 years, or 12 years after they purchased the property due to a generator of that garbage from prior to the closing. It could have been a renter, could have been a prior owner. There is not a good system in Lafayette, Lee, Pontotoc, Panola, where we can go and search the land records. We have liens that pop up years. I'll give you a personal example. My wife bought a house from a foreclosure in 2008. She paid cash for it. We relied on one of the best real estate attorneys in Oxford at the time to do the closing, as he represented the lender, and there were no garbage liens. She has since used that property for cash out refis as collateral multiple times over the next 14 years. And last year she started a business and used the house as collateral. Bank ordered a title search and found a lien that was filed from 2000, that was due in 2006, that they filed in 2018. A foreclosure had happened in between there. We pay the taxes every year. We get a tax notice. Not once have we received any sort of notice of a garbage lien, any sort of statement, invoice. The tenant has been there 6 years. They've never received any sort of statement. They're not aware of it. And she has a $3,000 garbage lien assessed against her property. She either has to pay it or she doesn't get the loan. She was going to sell the property. There's not a great way for her to address the validity of the lien. I contacted the county attorney, David O'Donnell. I said, David, you know, this is nonsense. He said, I'd love to work with you. It's a real problem. We got Three Rivers involved. Things get filed 5 years late. Sometimes houses have transferred 3 or 4 times. And who do you assess it to? How do you find it? Are they using a 911 address or legal description? It's not in the sectional index. And most importantly, he said, if you can show me that that lien was not in the record when you bought the property, then I may be able to help you. It's really hard to prove when a tree fell on your property. Okay. What year was it that tree fell on your property? There's no filing date. There's no, and I'm talking specifically about Lafayette County in this situation. There's nothing in the books. The books disappeared around 2014. Three Rivers went to a computer system, and those numbers changed. The penalties seem to be overwhelmingly high and cumulative. And so we've got to figure out a solution for it. We're here to provide a couple of options that we think would work, and work with the other participants in this, Chancery clerks, tax assessors, circuit clerks, figure out what makes the most sense. But the newspaper article from Itawamba County from several years ago, I think you guys have been provided a copy. If not, allow me 2 minutes. I can tell you some things that were put in that article that are just eye-opening as far as people's experience goes. You familiar with that?
Hey, I would like you to continue with your problem. I don't want to move to the solutions just yet. So if you want to continue with the current situation as you see it, please do.
Yeah. So this is just one example. We found that it's pretty consistent around at least about 30 counties. Mr. Rogers purchased a house in 2019. When he went to get his car tag a year later, the lady gave me 2 pieces of paper and said, these will have to be paid before you get a car tag. The paper was a bill to one of the property's previous occupants, a tenant. It was last billed in 2008. The renter left owing $385 and another resident renter skipped out in 2012, owed $169. The new owner only notification he received concerning the unpaid bills was when he went to get his car tag the next year. He walked away thinking, I don't have to pay this. It's not my name on it. I wasn't even the owner then, and it wasn't a record when I bought it. He was wrong. He did have to pay. The lien prevented the property owner, the new property owner, from purchasing motor vehicle tags, even though they weren't the person that accumulated the debt. According to state law, and I'm reading from the newspaper article, unpaid garbage debts are attached to the physical property, not the owner. This helps counties collect monies owed to them. Typically, a title search would uncover any liens. This one was filed years after the title search and years after the purchase and applied to a garbage lien that was due 7 years in the past. The title search didn't turn up any liens, but yet everyone was embarrassed from the process. He had not received any prior notice, and he was told he'd have to pay the outstanding debt. He called his closing attorney and they went to the Board of Supervisors. They argued that this has a negative impact on the poor. It prevents people from driving and getting to work because they're unable to have a car tag. It has an adverse effect on indigent, and it potentially causes criminal issues and arrest. Someone's pulled over for not having a car tag because they have a $3,000 garbage lien from a tenant from 7 years ago. He explained to the board that he had no idea that the prior residents had racked these garbage bills up, but the Board of Supervisors was unwilling to help. He asked about making partial payments of $100 a week until he had enough to pay it off, and he was denied. The county attorney stated it was our understanding Mr. Rogers wanted to get his tag and pay the debt off in installments. That's just something we're not able to do. Attorney Bo Russell told Rogers that partial payments aren't allowed under state law and the debts to the government cannot be forgiven. So that's something that has happened just about every county in which we practice in. There's multiple examples. The article goes on to talk about the lack of notice that the county failed to actually mail notices to the address in which the property owner was assessed, in addition to the property itself. And that they all use a system for garbage bill collections, at least in Itawamba and Monroe, developed by Three Rivers. Prior to the use of this software, a quarterly listing of delinquent garbage bills would be printed and kept in a book at the Chancery Clerk's office. They would be updated sometimes irregularly. These seem to have disappeared now. In 2014, the books seemed to be no longer necessary, and Three Rivers installed computers in certain courthouses. The system would automatically flag the property if it was over 90 days old. It isn't entirely clear why some unpaid garbage bills have gone on for 7 to 12 years, only to seemingly resurface after the previous owners are long gone. What we're dealing with.
So I'd like to stop there before we move into any other situation. Do we have any questions from the committee that's here regarding the problem itself from your perspective?
I'd like to.
Representative DeWeese, please go ahead.
Thank you, Senator McCon. Mr. Hammonds, it looks like among my colleagues here, I'm the only non-attorney. So a couple of things. I am in real estate and I've sat at closing tables and I've dealt with this issue. As a representative, I've received calls recently of people trying to get car tags and are unable to do so due to unpaid garbage liens, and they are the non-originator of that lien. Could you help me understand the process in which you discover other liens on properties, whether it be a workman's lien or tax lien, whatever it may be? Walk me through that process.
Sure. In Lafayette County, either our office or our abstractor will perform a title search and check the several indexes. Of course, they'll also check the circuit clerk's office for any judgments against predecessors of title. At that point, a construction lien or any sort of lien of record or any sort of lawsuit that's been converted to a judgment will be found. We will have constructive notice of that because it is in the land records and all parties are deemed to have constructive notice when it's filed. Or you could even have some sort of actual notice because those parties would have received an actual claim or a lawsuit notifying them. We don't find that there's a consistent process for these being filed in Fayette County and other counties, and they're filed retroactively, which is a real issue. We check title and find that there's no garbage liens and close it, and then a buyer calls us and said, we can't get car tag and we paid you, we have title insurance. We don't even explain that this isn't a real lien, that was not record notice, but in the land records. Or that it was filed after. They have a hard time understanding that. They really have a hard time believing that because they trusted you to make sure this didn't happen.
Can we stay on other liens, construction liens? I would imagine homeowners associations can file liens for unpaid dues.
That's right.
What have you. Once you discover those, whether being clerk's office or however you may discover it, what's the process then to collect from your end?
So in a construction lien or homeowner association lien, we would have notice of who the claimant is, the amount owed, some sort of evidence of why it's owed. How did a homeowners association go from $100 a month to a $4,000 lien claim? There would be some proof or statement showing that, and you would have the ability to work with the seller, the party that it affects, and have it negotiated or resolved prior to closing. But at a minimum, it would be handled before closing to ensure that there's proper title. Those are all filed in the land records in the Chancery Clerk's office, either in a construction lien book or otherwise in a sectional index.
And my understanding, having seen these before, is you would have a settlement statement. Those liens would be itemized on there, and they would be deducted from seller's proceeds, or in this case, the originator of that lien.
Be treated just like a deed of trust.
And so I guess I'm confused on what makes a garbage lien any different than any of these other liens that are discoverable by you as a closing attorney doing a standard title search.
Yeah, we believe the garbage lien is a misnomer. It's not an actual lien. It's not properly filed, and there's no notice that's provided. We have recorded phone calls. We have taken pictures of garbage lien books to prove our innocence, to show that things were recorded or not even recorded. They're not even time stamp filed. They're just put in a book, sometimes months and years after closing. So in that situation, if we're aware of them, we handle them. And if we're not aware of them, as Bronson Tabler and Robert Bass, Nicholas Brown, and several others that I've spoken with this week, we just end up paying them. Bronson's paid over $10,000 in liens that were filed after closing that kept his buyer, his client, from receiving a car tag because it was just too embarrassing, or he didn't want to explain it to his client. And even if he did, they wouldn't understand it. We've spent thousands of dollars arguing Three Rivers and the garbage lien, the garbage collecting entity at the courthouse to try to get these resolved. And it's just unfortunately very embarrassing.
So you are aware of situations where a lien has popped up after the transfer of property and the originator is there?
Just in this situation from Minnewaca County, 7 years later. In my wife's situation, she bought the house in 2008. It popped up over 10 years later.
Senator McConnell, I know you mentioned solutions later, but I'd be very interested to hear what LTM solutions.
Absolutely. And we will definitely get to that in just a moment. Thank you. Senator Suber.
Just have one question. Mr. Havens, I know you and I have talked about this for years, and this is something we both kind of trying to work to a solution. I currently do not have a car tag because I bought a piece of property, no garbage lien. I sold the piece of property, no garbage lien, and this year last year showed up that there was garbage lien, so I can't go get a tag, and I'm trying to get that resolved. So, I understand completely. Three Rivers is, the one that handles the garbage up in our area. Have you talked with them? And what is their response?
We've not been very appreciative of their efforts to explain. We'll provide documentation or why the amount changes. We do have a closing staff that will call and try to obtain the amount of the lien. We'll document that, try to get it in writing, try to ask for invoices or receipts. Many times, I was explaining to Senator Boyd, we can only get a screenshot of a computer screen. not an actual printed statement. It's a very frustrating process. And then once we mail the check after closing, they won't accept it because there's a $12 difference because another month has passed. Instead of applying the $384, they want $396 now. So we'll just write a $12 check, frustratingly, take that to the office and have it paid.
And
There's a real problem in North Mississippi with that collection entity. When we've called them, they say, oh, well, we're still working on the 2017s.
now, is there any statute of limitations on any of these liens? Or quasi lien, as you would say?
There's some conflicting attorney general's opinion about how they're prioritized, whether they survive a foreclosure. There's not much clarity. We've discussed with Chairman about 3 to 5 year statute of limitations. And even if the county wants to re-enroll the lien, that's fine. We want to see these bills paid. We want to see these monies collected. We just want to find a way that it doesn't affect the innocent purchaser, or it doesn't prevent someone who needs their car to get to work from Batesville to Oxford or vice versa from getting pulled over on Highway 6 for an expired tag.
But on everything else involving a title, is there some kind of statute of limitation that's attached to it? You know, like a federal tax lien, and it's what, 10 years?
Yeah, each type of lien has its own priority. Some survive foreclosure, some don't, depending on what they are. And in this situation, I believe we agreed to a 3 to 5 year unless it's refiled.
But right now, there's no
There's
kind
not,
of limitation.
no, I'm arguing about one from 2006.
And see, and that's kind of,
There's no notice.
right. And that's kind of my issues. A federal tax lien's 10 years.
Right.
Of course, it can be,
Renewed.
renewed, a state tax liens, 7 years, or any kind of judgment, 7 years.
Right.
Well, the garbage liens seem like they're going on forever.
Right.
And it's, to me, an issue. But appreciate you coming down today. Like I said, I look forward to working with you to come up with some solution.
Yeah, like you're saying, we have many examples of from Prentice, Itawamba, Monroe, Lee, Pontotoc, where liens have showed up 2 years after closing and applied 10 years prior.
All right, Senator Brent. Senator Wiggins.
Yeah. I need some education here. Who's filing the liens for the so-called? Who's doing the filing?
Different counties handle this differently. I think that's what you're trying to figure
This
out.
may be your solution.
So, and let's just clear this up just a little bit. Counties in general are charged with the collection of this waste. In this situation, my understanding is Three Rivers been contracted. And do we have a Three Rivers representative here? Has been, you're on that board. They've been contracted to pursue and to handle the collection in these counties. Now, across the state, other counties handle it differently. They may do it of their own accord with their own office. But as far as there's no provision in our code right now that requires the filing of a lien. It just says, just as a water bill, and this is my understanding, please correct me if you see it differently. We've got legal counsel here, like a water bill in association. Once it is, the service is rendered upon the individual, then it becomes a lien that is not forgivable under state constitution because it would be an illegal donation. That's the argument that you hear from the outside. Now, as far as are you required to have a registry? Are you required to have a filing? That is part of the discussion today because the notice provisions are not clear within the code section. And that is one of the things we want to discuss and figure out. Does that answer the question there, Chairman?
Yeah, you did on my question. And listening to just this part of it sounds to me like it's being handled differently and not correctly, to be honest.
Yes, sir. I believe that of the final premise is without notice, how are you assessing this as a lien? I mean, and that's what it comes down to, I believe.
And I don't,
But my question is, so did the supervisor contract with whoever, the statute, I think says, who's ever generating the garbage, are they contract, is it the person who's cleaned up the garbage and not been paid for it?
So don't we have supervisors here? We have supervisors. We have an individual supervisors here that can speak here in just a moment on where they see the problem is currently on the tax And I believe that's probably the next step we're gonna go to. And I want you to stay right there, Mr. Heyman, because we've got another spot, because you will be back on the hot seat here in a minute when we discuss solutions. Senator Boyd, have you got questions for Mr. Heyman too?
I kind of want to just make sure that we reiterate something that I had a discussion with Mr. Hammonds earlier is one of the also problems too is that when you do go back and you get these liens, is that you're not able to really see the dates of service, who the individuals were. There's a lack of information and specificity. So that if you wanted to contest this, that it's very problematic to say that this indeed was owed. And I'll let you explain that a little bit.
You're right, Senator. We find that there's not a lot of notice, probably a couple of due process issues. We don't find that we're given any sort of record of account. We find garbage lanes assessed for up to 10 years, ceased parties. In my own particular situation, my tenant moved out in 2016. Power was turned off, the property was vacant for 3 years. We had accrued over $3,000 in garbage expenses, and there was no occupant. And building didn't even have power. Some counties will pick up their garbage collection on their utility bill, which means your power gets cut off, your garbage gets cut off, and if you want that, you get it cut on pretty quickly. It's not allowed to go 3-10 years. But as the senator and I were discussing, you cannot get a lot of information to even argue the validity of the time period. And the only two arguments Bronson Tabler and Robert Bass were able to ever make that got some relief is when we were able to pull utility records to show that the property was vacant or that it subdivided and split off several times, and that 911 address is no longer associated with the larger parent parcel. That's another problem. Are we searching 911 addresses, or are we searching an index with a legal description? And so we find that when we do try to argue that we spend more time proving that they're invalid, that it's just cost effective to write a check.
Senator Boyd? All right. I'm gonna ask supervisors, you got just a moment? Come on up. We want to just chat about just a few little problems from your angle and your board's view. That one should be on. I'm sorry, and we have Senator Angela Turner Ford on Zoom. Senator, do you have any questions you want before we move on to supervisors? Senator? All right, we'll move on. She can ask in a minute. Map supervisors, please state your name for everybody.
Thank you, Senator, Mr. Chairman, and to the committee. My name is Steve Gray. I'm with the Mississippi Association of Supervisors. I've been with the association going on about 15 years. And first of all, thank you for bringing up the issue of garbage. This is something since the inception of my employment, we worked to try to make better in the counties. Collecting debt has always been a challenge. Even before my time, the whole notion of the power to hold the car tags was something that was utilized to try to help with that. It's sort of a double-edged sword because counties also not receiving revenue from the tax which they collect. So we've come to the Capitol, and for years, members have helped us. In 2008, I think at that time it was Senator Haskins Montgomery. We got a bill passed to allow for special assessments for non-residents property owners. I think we came back the following year in 2009. And at that time, Senator Tollison helped us to remove that and apply it across the board. And in 2019, you all helped us with House Bill 991 with the debt set-off legislation to help try to collect as a part of that total assessment. I say all this because there's really no one way to try to fix this problem throughout the counties. Some counties put it on millage. Some people see that as unfair.
Well, let's back up. We're still talking about the problem right now. What I'd like you to do is just let us know across about all of your people across the state.
Right.
And the counties that do have problems collecting.
Yeah.
The counties that have arrearages, because I know there are counties out there with substantial arrearages. And every dollar that they're not collecting is a dollar that my tax dollars have to go to supplement.
Absolutely.
So that's what I'd like you to touch on just a moment. Do you see there being a problem out there?
There's a major problem with that. And again, we're open to anything you're willing to offer to try to help us move forward with that. But I just wanted to announce those things because to show we made an effort to try to fix that, and we're still having challenges going forward. Yeah.
And let me ask you this: across the counties, there is no one way of collecting it. Nobody's using the same method, are they?
Right, there's really no silver bullet, and it's also political, if you look at it sometimes with the millage situation, but you know, they do what works best in that particular county and just kind of move from there, whether it's contracting with a third party, like with Three Rivers, or however they choose to do it. Yes, sir. All right.
Question for the supervisors before we move on. All right, we've got other parties to talk. I think most of them are here for solutions. Is that right? Mr. Ladner, is this what y'all were looking for? Or do you want to talk about the problem? Come on up. Let's talk about the problem. I want to get all that out of the way before we move forward, because once we determine there's a problem, I want us to find solutions.
Glad you have a coast guy on.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. Well, thanks committee for letting us come. I don't think you can talk about the problem that we're talking about without talking about the larger problem for the counties particularly, which is the non-collection of the garbage fees up front before they even become a delinquent debt. Just as a little history, when I took office in 2000, Hancock County, who billed about $500,000 a year in garbage bills, had over $2 million in delinquent garbage bills. So it's a huge burden on counties. It's a burden that we, the counties, still have to pay the contractors that are picking up the garbage. We still have to pay, if it's being done in-house, the teams, the county crews that are picking up the garbage. So it's an issue. I recognize the issue that closing attorneys have. Have a daughter that's a closing attorney, so I hear it at home as well as at the office. So I can appreciate that. Part of the problem that we've had, though, is that there has been, for lack of better words, no teeth in the law that would allow us to go after the collections, with the exception of the car tag issue. Now we do it in Hancock County now. We do it very aggressively. We have a collection rate of about 92% on any given year, which is as good as you're going to find anywhere in the state. And we still have issues like you're talking about with closing. Now, if I may, I don't know, we do have a solution that we'd like to offer. If I could go that route, it's up to you.
Are there any other problems? Anybody just want to talk about the problems before we move forward?
Did want to make clear before we go into solutions on the car tag, which just seems to be your main
Yes, sir.
team. Supervisor said a double-edged sword on collecting that car tag revenue sometimes, especially in the poor counties. But do you believe that it's applied correctly? You keep a third-party purchaser from getting a car tag when they had no knowledge of the lien? That seems to be somewhat problematic.
We do not, in my county, I can't speak for the other 81 counties on this particular thing. In my county, we would not keep a new owner from getting their tag. We would do the research that's required, and we would put the lien against the original owner of the property, right? Not against the new owner of the property. In Hancock.
But are you putting the lien on the property? Or are you just going by the individual or the property?
We would go by the individual. We would not go after the new owner of the property, for lack of better words. Okay. But now we aggressively go prior to that. I mean, if you come into my office, you're going to be able to pay your property taxes, your personal property taxes if you're a business owner, buy your car tag, and pay that dang old garbage bill as it's called, all with the same check.
All right, Senator Super, any more? Senator Brandon caught me too. I'm gonna recognize her for a moment.
I just want to make sure I understand. It sounds like in your county, what y'all are doing, the lien is following the person and not the property, as opposed to Lafayette County, where the lien is attaching to the property, not necessarily following the person.
Yes, ma'am.
Okay, thank you.
And to clear that up, Mr. Ladner, can you speak to the options available for the collection of garbage? Because I think the statute allows for several options. Can you bring those up for us?
The statute allows for several options, on car tags being the most aggressive. You can hire a collection agency, pay on top of it. But I can tell you all of those options that have been tried with the exception of the car tags, has been very unsuccessful. There's even some opinions out there that say that a county can't do more than one option at a time. So Hancock County could not use the car tag option and use a collection agency at the same time, which causes some issues. So our hands are tied to one option. So you have to go with the one that works best in your county. In our county, the car tag issue has been the one. And look, trust me, that doesn't come with a lot of gnashing of teeth. I mean, as a brand new tax collector in 2000, I was not happy the second week I was in office when the board issued an order for me to hold car tags for delinquent garbage bills that were 10 years old. So I get it. I understand what you're saying. But, you know, I think that we have a way of addressing this that would even address the notification issues and everything else.
And I believe we're gonna get to all of that here in just a minute. I just want to clear up for the record, the other option would be the judgments. Is that right? Isn't there an option to file a judgment against these individuals?
Yes, sir, there is. And
But you can't use any of it. You can't use but one. And your determination comes from your board of supervisors. Is that not correct?
Yes, sir, that is correct.
So once they tell you how you're gonna do it, that's your pursuit option.
Yes, sir.
Additionally, the other thing that I want to clear up right here with the group is we've talked about partial payments. Currently, there is an attorney general's opinion, and there's some authority out there that says you can't accept partial payments. Whereas we do have, if you akin this to a public utility, where there's some authority out there that does allow partial payments for a water bill that's $1,000, where we can't do it now on garbage lanes. Is that your understanding?
It is, and there's also the option of a hearing officer. And when the hearing officer is used, that hearing officer can put in place as part of the due process, how that is going to be paid. And I've seen that done some counties.
But your final, and I've got two right here that are each and ask a few questions. But your final premise is you're utilizing the one that you feel is best
Yes, sir.
in your county currently.
Yes,
Is that
sir.
right?
And that's not actually a feeling, to be completely fair. That's supported by historical fact.
Yes. All right. Representative Deweese?
Sure. I don't know if this question is for Mr. Ladner, Mr. Hammond, any of us on this panel, but I want to kind of tie this to any other utility that we have. Let's say we don't pay our cable bill. What's the recourse there?
I would assume it's shut off.
It's shut off. If I don't pay my water bill, what's the recourse there? If
It's shut off.
I don't pay my garbage bill, what's the recourse there?
It continues.
It continues, and if I could go further, I agree with the gentleman, it continues, but this is why. When you're dealing with garbage, you're gonna pay for it one place or another. You either pay for it to be picked up out of the can in front of the house that the person is not paying the bill, or you pay the county road crew to pick it up down the side of the road when they dump it.
If the county decides to.
In our county, we would pay the county road crew to pick it up on the side of the road.
So
Yes, sir.
back to the way Hancock County handles it, you find the originator of the garbage.
Yes, sir, we do our best to.
And that date starts when service is applied for, it would be my assumption.
Yes, sir, and we have a way, I think the gentleman talked about this with some of his issues too. We work very closely with Coastal Electric Power Association, and they will provide us the start and end dates of when the power was put on, and we use that to determine when that person was the responsible party for the garbage at that house.
But the responsible party is the responsible party until that service is terminated by that responsible party and then picked up by someone else.
Yes, sir.
Okay, thank you.
Senator Boyd, have you got follow-ups?
How many, are you aware of the counties, how many use what procedure? Do we have a breakdown of that anywhere as to which counties use what?
No, ma'am, I'm not aware of that number. I can tell you that it's split about evenly the last I looked as far as what counties use a fee and what counties use millage to pay for it. And I think it's 39 that use the fee, and about 43 that go the other way.
To your knowledge, are the majority of counties using the car tag as the process that they use?
Yes, ma'am, I would think that would be a fair statement that the majority
Okay.
of the counties that have this issue are using the car tags as the mechanism to collect.
Okay, thank you.
All right. Any other discussion on where we are? We know it's a problem. I think we pretty much beat that dead horse. We know it's a problem. Let's talk about what we can do. Currently, we've heard that you've got the car tag, you've got the third party, but we've also heard that there are parts of those that are not working. Mr. Ladner, I know you've worked recently with some individuals, I believe even this week. I'm going to call you first to tell us where your consensus is to bring some options to the table. So I'm going to recognize you to do that.
Thank you, Mr. Chairman. The consensus that we have as county officials that are the ones that are charged with trying to pay for this on the backside when we're paying the contractors is the law would provide us to put this on the tax bill right now. It provides us to put it on the tax sale. What it doesn't allow us to do is sell it for the debt. It doesn't allow us to do the same thing that the law allows us to do right now for a cleanup. Say if a city has a cleanup that they want to pay, they can put that on there, and if the tax bill is $100 and the cleanup is $500, we can put the whole $600 on the bill and run it through the tax sale and collect it. Garbage is a separate animal. It doesn't allow that. Even if we put it on the garbage, if we put it on the tax bill, if they send us a check for that same example for $100 for the taxes and don't send us the $500 garbage bill, we have no recourse. It's over. We tried, we ran the bluff. It's over. If we were allowed, and there's one sentence in the statute that says no real or personal property shall be sold to satisfy any lien imposed under this subsection. If that was removed and we were allowed to do that, it would address his notice issues because it would be included in the notices that go out for delinquent tax sales for the Chancery Clerk's office. It would address his notice issues from the point where when it was going to mature, all that would be on there. It would be noticed 2 consecutive weeks prior to the sale when we ran it in the paper that we're required to do. And what I find attractive about it as well, counties send their tax bills out in December. So if you had a property owner that had a dispute over the garbage bill that said, this is not my garbage bill for whatever reason, I didn't own the house, he or she would get that tax bill in December and have all the way to the last Monday in August to address it with the responsible parties at the county level. I mean, it would utilize the system that is already in place. It would utilize the computer programs that are already in place. All we would do is add one line to the redemption sheet in the Chancery Clerk's office. It's the most cost effective, the least intrusive. I mean, the easiest way to get notifications. And I get it. I understand some people's going to say we can't sell somebody's place for $150 garbage bill. We sell people's places for $150 tax bill every year in a lot of them. So we collectively, county officials have looked at this and met with this, understanding some of the criticism that we get back home for supporting this. Still believe that it is the most effective way to handle this, and it would handle this issue not only for closing attorneys and real estate people and all of that side of the issue, it would handle the financial issue from the counties and allow these delinquent garbage bills to go away. In the future, we would be able to run our garbage accounts knowing what kind of revenue we were going to get. I mean, because look, truth of the matter is right now, if Jim Ladner don't pay his garbage bill on August Ladner Road, he saves the $15 a month, sure. But we still pay Coastal Environmental, who is our contractor, that $15 a month. So that money that we're not collecting across the board, across the state for delinquent garbage bills, is coming out of general fund. It's coming out of folks' pocket because it's being made up by millage rates. So in effect, the people that are paying their garbage bills are paying higher taxes for the people that aren't paying their garbage bills. And that's just as true as it can be, because we don't have a pass on paying those contractors that are doing the work. This would fix that as well as fix their issue.
All right, I have one quick. You bring up tax sales,
Yes, sir.
and there will be hearings on those. Do you feel like, or from your perspective, are we passing the buck on to another problem?
No, sir, I don't. Because
So do you feel like tax sales are good and valid? Because I set them aside every day.
tax sales, there are always going to be some sales that are set aside. One of the larger issues is bankruptcy, because we don't find out about the bankruptcy after the sale most times. So those sales are set aside. There's some that are set aside for erroneous assessments for whatever reason. My sale in Hancock County, we will typically take around 4,500 parcels to the sale. And on any given year, we may void 25 to 30 sales. So from my perspective, from my experience in my county, yes, sir, it's a very good thing.
Okay. I'm going to open before we bring on any of our other experts that are here to testify. I'm going to open the floor for questions from our panel here. Does anyone have any questions from your legislators first? Senator.
Now, what statute were you referencing that we need to look at?
It would be 19.522 in paragraph 2.
You feel we could add, or the possibility of looking at maybe adding garbage lanes to utility bills, water, because of our cities, it's associated with our water bills. Would it be something to look at, maybe attach them to like our rural water associations or something similar?
Could that work? Yes, sir. It could work because they could shut off the water and then that would, look, as harsh as that sounds, that's the reality. The reason that works in those places is because they can shut off the utility that's tied to. In our municipalities, Bay St. Louis, Cleveland, we don't have that issue because it's tied to their water and gas bills. It's in the rural areas that we have the issue because that's the only service that's provided. Now, the problem with trying to tie it to other utilities is some places don't have other utilities. I mean, in some places, there's just literally no other water, no other sewage, no other anything to tie it to. That's probably not as bad in our county as it is in some of the other ones. But even in ours, we still have some very small areas of the county that doesn't have either a rural water association or another kind of utility district, fire and sewer or something like that. So, and I would also, in complete candor and fairness, tell you, they would probably be beating on the doors against it when it hit because they don't want it. Nobody wants to deal with garbage. I can tell you in 2000, I got legitimate life threats over holding guard tags or garbage.
Senator Brandon.
Just trying to wrap my mind around this. So let's just say this scenario that you're describing is something that we work with. In your office, if I'm coming down to abstract a piece of property, in order to make this work, you're going to have a garbage registry, I assume, somewhere that I can go to a computer, just like I would do for someone's real estate taxes and look to see what is there. Is that sort of what you're envisioning?
Well, actually, what I'm envisioning is when you went to pull the redemption sheet in the Chancery Clerk's office, just like right now on that sheet, it would have a special assessment. And what that special assessment is, a cleanup, a condemnation, something like that. We would use the exact same situation where it would be a special assessment and it would just be a delinquent garbage bill.
Okay, so you would be using your existing system and just adding a line item for this issue.
Yes, ma'am. Now, that would still, in complete fairness, would still require the abstractor, because that lien would be from January 1st to December 31st of last year. It would still require the abstractor to go and see if that person has paid his garbage bill from January to May. Let's just say if the sale is going in May. But what it would stop from happening is 10 years worth of garbage being given. But that would be the exact same thing as any other utility that's on the bill. That would be the exact same thing that any other utility that is running, whether it be water or gas or whatever.
Or it could be prorated at closing and handled by the seller, so that part's out.
Without, I mean, everybody that I've talked to in the closing world and, in the real likes this idea from a financial standpoint and from a standpoint of using a system that is already in place that works.
So you would make the lien discoverable currently?
Without a doubt. Yes, sir. That's exactly what we would be doing. And you would remedy the notification process as well, because the clerk is required to send certain notices out prior to maturity of the sale. And the tax collector is required to run 2 notifications in 2 consecutive weeks before the sale, as well as sending that tax bill out in December and giving that property owner 8 months to address it if it's not his or hers.
Right now.
So let me clarify this in my mind. We're not talking about a blanket assessment for any improved property on the tax bills. We're talking about you continuing your registry, which you have a registry.
Yes.
You have a searchable registry is what you're
Yes, sir.
telling this committee
Yes,
in
sir.
your county. And from that registry, at the end of the year, you taking the remaining garbage bills and you tacking it on as a special assessment on those bills that come out whenever they're printed in the end of November.
Yes,
that
sir.
come out in first
That
place.
would be the,
That's your recommendation to this committee,
yes, sir.
is to allow the filing of those from the registry onto there.
That's right. I am not talking about saying, and I want to make this clear as well.
Yes.
I'm not talking about the board saying, okay, instead of having a billing system for garbage, instead of doing all this, we're just going to say automatically that it's $140 a year we're going to add to your tax bill. I am not talking about that. What I'm talking about is from our tax billing system, if there's a tax bill that's late for the year, the board would have the opportunity to put the lien on just as if they were doing a cleanup in a community.
And you are continuing, I guess from that, I gather, you would still send out your quarterly or your yearly tax bills.
Yes, sir.
People come in there and pay them.
Yes,
And
sir.
at the end of that year, if they were not paid, that's when you would do your assessment.
Yes,
Is
sir.
that correct?
Yes, sir.
Is that the understanding of the committee? Is everybody clear on that? Yes.
You would still allow the county, or your proposal allows each county the flexibility to determine their billing method per se, this is a way to document the lien.
Yes, ma'am. This would do nothing to hinder the billing process that we have right now. We bill quarterly in Hancock County and it works well. And I think by doing this as well, I would hope that we could make sure in the language that would also allow us to continue the car tags in the county where it's working.
All right. Two more questions while I've got you on the hot seat there. As far as partial payments, do you have an opinion on to that? And I'm asking you personally. I know your association probably has not given you that official opinion, but I would like your opinion.
Speaking strictly as the Hancock
Yes,
County tax collector, we take partial payments, but we take them once. If you come in and you have an issue that your garbage bill, is bad, we will come to a resolution with you on how much you want to pay for it now and how much you want to pay for it going forward. And if you maintain that and you come back in next year to get your tag, because we have that record of you agreeing to pay $100 down and paying an extra $40 a quarter. If you've maintained that, we will allow you to continue to get your tag next year. But if you have not, then you have to pay the whole thing for us to move forward.
Follow-up question on that is, your proposal takes into account the requirement for there to be a formal registry of these garbage liens.
Without a doubt. You can't
And-
have a collection system without it. I mean,
And would that be the recommendation of your association or just you?
that is a recommendation of not just my association, but the associations that are represented here as well.
Okay, so that is a discussion, and I want to clarify that for those at home. Can you tell us the associations that met and came up with this?
The Mississippi Assessor Collectors Association, and I would let the other associations identify
But
themselves.
just who all came in there with
Okay,
you
the
that day?
Chancery Clerks Association, the Supervisors Association, and the Circuit Clerks Association.
All right, so those all came together and had a discussion, and you're presenting that on their behalf. I'm going to allow them time to speak here in a moment, but I wanted to clear that up. for
Yes,
the
sir.
record
That is
as well.
correct. Yes, sir.
Additional questions now for Mr. Ladner before I turn it over to Land and Title to ask him a few questions, I'm sure. Land and Title, have you got any questions, Mr. Ladner?
I think that's one of the great solutions. We struggled with trying to tell the circuit chancery clerks how they need to do their job or incur any fees. We've always felt that the special assessment on the tax roll would be the cleanest and the easiest. We were concerned that Three Rivers not being here, being a stakeholder, would be cut out with the way Mr. Ladner presented. I think it still allows them to be involved and stay in the collection process. Our concern is, what do you do with the gap? From the point the legislation becomes effective, we need some protection, at least for the future owners going back, if we know that they're being filed 10 years in arrears. So if we could address how to deal with the gap and making sure, of course, it only applies to improved property. There's some things like that. I think while we're cleaning this up, we ought to make that clear. We believe that the cost being prorated at closing would nullify seller liability going forward once the legislation takes effect. So that's a great benefit. And I think I want to highlight what you said is the most important, is this keeps people on the streets, and it also provides immediate revenue for no more than 18 months out from the tax sale. And so these debts that are owed in 2006, 2008, 2016, it requires everybody else in this room's millage rate to go up. Should allow for some cash flow on a much quicker basis for the county. I think it's brilliant.
So let me ask you this scenario then, and I can ask the two of you, and then we can talk about it. I'm not going to hold anybody who wants to speak, I'm allowed to speak now, as long as within reason. But the scenario would be based on the way the tax liens were transferred over to an electronic database onto one site. I'm not asking for that, but I'm just talking about the process. There was a notation that any outstanding lien as of that date had to be recorded on or before a certain date for it to be attached to the land. Do y'all remember that? How this all worked with the tax liens? It went online, you had to file. Do you feel with that gap that you're talking about, do you feel like a potential solution may be to put in there, you've got 6 months to file all of your liens in a registry in your court or a year, whatever it may be, so that it becomes searchable and it becomes a record then. And then you can pursue your options, your assessments, whatever it may be at that point. Now, at that point, you may be looking at $1,000 assessment going on a tax bill, and y'all are just got to deal with that on your hearing basis as your association. But, you know, is there an appetite for that to be a provision that says every county's got until, say if it were passed this session, it got until December 31st of 2023 in which to file them in a registry in your county at a designation of your choice, so that it does become record. Is that an idea? I'm throwing that out there and the committee may want to comment on that. Mr. Ladner, have you got any idea?
I don't think a problem with setting a date. I would submit though that 6 months may be particularly hard for smaller counties. I will tell you, if that was the case in my county, I have the luxury of having a staff that's large enough to handle that. When you get into some of the smaller counties where there's 3 people in the office, including the assessor collector, that may be an issue. So I would like to see that time extended from 6 months, maybe to a year.
And that's something we can work through. I'm just saying in general, you've got to have a starting spot. And if you don't have a registry, you're going to have a registry, and you're going to have a time in which says, if you don't have it filed by this date, it's not an effective lien pursuant to statute. And I think that is a very fair alternative, but I want to hear all of the ideas from this committee and everybody else. So Senator Brandon, have you any questions on that or comments?
Yes, we just need to, in that, create an opportunity for a hearing or some way for the landowner to be able to come in and question whether the liens that are placed there through the new registry are in fact valid and should be attached to that property. I don't know what that is, but I would just.
I think at the end of the day, it may be to your board of supervisors. Have you two got any more comments or questions or at this point? I'd like to allow an opportunity for our other guests that are here. Mr. Stanton, I know that you're here with Mr. Armstrong. Would you like to address the committee in any way? And all the other questions I've asked him, are there any questions or concerns that I brought up there? Anything that you don't agree with that he said? All right. Yes, sir. Would you like to address us?
Chancery Clerk in Lee County. And so I'm also on the Three Rivers Bank. We are in complete agreement with the Chancery Clerks Association with Mr. Ladner as far as the process. The older issues are definitely something we've got to address. And I'm probably one of a handful who were around 30 some odd years ago when this was actually started. And the problem that the counties had in the past when they started, we had no reference to come up with a billing. So we went to power associations, we went to water associations. You had multiple indexes pulled together to try to come up with how you had a billing cycle, a billing group. Some of those were duplicates, some of those are triples, and then some of them, as they have passed through time, are still sitting out there, and they need to be. We need to have a way, as you're discussing, to get rid of them. The way that our county and several other counties contract with Three Rivers Planning Development District to do the billing. The billing is picked up through when somebody turns their power on. That's how that bill is picked up. So it is picked up in John Doe's name, who lives at my 475 County Road 520 Shannon. The issues we've had more in the past, now that we're kind of over the hump of the old ones that may still pop up, the issue we've had more in the past with our abstractors are that if John Doe is the owner of the problem, when they went to do the search, that was no problem. John Doe, you go to the computer screen, you can see if John Doe's there, that's fine. And they do take us, my abstractors in my county, take a snapshot of that date and put it in their file. And to my knowledge, we've had, since that process has gone forward, we've not had any issues, except the old ones that pop up that wherever they've been, I don't know, but how they got there. But that's how they determine that. The problem then became, well, John Doe may have been renting, and that's who turned on the power, and we had an address. We don't have that linked to a parcel or a section, township, and range. And so now our abstractors are also looking at, and typically in the past, when they got from whoever was closing the loan, they got Bill Benson, here's your property description. They didn't get Bill Benson, and here's his address is 475 County Road 520. And they do now do that. And so the Three Rivers process now is real time in our office. So that if you will know today, if you take that snapshot, that it's good or bad. Other than, again, I certainly will agree that the old ones pop up and are issues. But the gold standard for correcting that is exactly what we're talking about. We're 100% in. The collectors and the chancery clerks are going to get the ones who are going to get fussed at about the when it shows up at either place, but it's worth it, and the county gets their 100%. We've got $2 million, over $2 million on the books, and we're at 93% collection in Lee County, but we still have over $2 million on the books.
So let me ask you this, since we have all of you represented, and I would love for y'all to get to an agreement on who gets to house. Because there will need to be a registry, and it will need to go in some office, and it will need to be updated. And it needs to be in that courthouse, not on a third party's location. So ideally, has there been any discussion on which office that'll be housed in?
And I guess again, the question I've got is what you're defining as a registry.
There's got to be a list of outstanding.
We have a list. We have a list of outstanding garbage bills on the computer in our office, in the Chancellor Clerk's office in Lee County. And as I understand it, every county that's billed with Three Rivers now has that situation.
Well, but I'm not going to sit here and say that Three Rivers is going to be in 82 counties.
Right.
That's not what I'm here for.
But I agree that there has to be that list in every office. I don't have an issue. My opinion, probably the abstractors are running most of it in the Chancellor Clerk's office, but
I'm sorry, I'm out there, but I would suggest that list should be in the agency that's doing the billing. Like in Hancock County, that does exist in the Hancock County Tax Collector's Office, because we do the billing. I mean, and you can online get it, you can come in the office, we have public access, whatever, pull up Dicky Ladder and see if you've got more.
Well, I think that the question there is, I don't want for us to get in here drafting this legislation, and all of a sudden, we come into a roadblock because somebody's offended because they're not being paid to keep up a list. We're all county officials. You're all county officials. At the end of the day, you are handling and you're stewards of the taxpayer dollars. We can figure this out. And that's what I want us to know.
And we're not being paid.
Right.
The list is there, and I don't want anything I don't want to touch it. I don't want to fee. I don't want anything to touch to garbage but as far as providing a list, I would agree with Mr. Latcher. Not the billing, in our case, it won't be the billing agency because Three Rivers is the billing agency.
Right.
It needs to be in the courthouse, whether that's in the Chancellor Clerk's office or in the
Tax
the tax assessor collector's office is of no real concern.
Well, I just,
to me, and I don't think to the association, it's whatever you all deem is the better place.
well, I don't have a problem putting either one in. The required list to be registered to be housed in either the tax assessor, Chancellor Clerk's office, declaration for the board as to where to be housed, blah, blah, blah. We can do all that.
Just here, I would suggest that any tax collector, not necessarily.
Yes, right. And we do have the counties that have the dual, so, committee, additional questions here? Bernie? Senator Turner Ford, I know you're still there. Do you have any questions or comments you'd like to bring up?
No, Mr. Chairman, I don't have a question, but I just would like to comment if I may. It seems as though I think a logical place would perhaps be the Chancery Clerk's office, where a physical lien book would be required, such as the construction lien registry. If, with the association that the tax assessor has with the Board of Supervisors and the Chancery Clerk, and the Chancery Clerk being the official record keeper for certain county records. And I guess I'm kind of speaking based on the relationship that I have with my local county. Their garbage fees are collected by the PDD, and perhaps if the PDD surrenders its list of outstanding liens to the Board of Supervisors and they're actually recorded in a registry, that may address some of this in terms of formulating a process where the liens are documented on an annual basis, such that we don't have these pop-ups 6, 7 years down the road. So I just wanted to make that as a comment. Thank you.
Thank you, Senator. I think that is a well taken comment here. Ideally, we would love to have these in real time, so they are a monthly or at least quarterly real time registry where you can go and search. Is that going to be something that we require? I don't think so, but I do agree with Senator Turner Ford there that you've at least got to have a lien filed, whether it be quarterly, whether it be yearly. The $100 lien doesn't bother me as much. It does when I have about 10 of them, but whenever you see additional lien amounts, I think you do have to have a registry, and I agree. So, Mr. Stanton, you got a few comments?
Can I have one question?
Yes, sure.
Just for my clarification, so in order to prevent these 5, 10 year down the road pop-ups, it would be up to the supervisors or the collection, the county part of the collection to get with the third party to get those liens filed on a yearly basis. Is that what we're saying?
What we've just mentioned is that we would put a time frame in which all outstanding liens shall be required in that registry, just as they did with tax assessors and everything else, so that you have a cutoff as of, discussion was a year out, say it was January 1st of 2025, that as of that date, there's no other outstanding liens except those that are of record on that list. So, yes, Mr. Stanton. Mike, and you can just stand there if you want, just get close enough they can hear you.
Carroll County is unique in a lot of ways, in case you haven't figured that out. One of which is I'm the circuit clerk, and I'm also a deputy chancellor clerk. The other is we have 2 courthouses, and our sanitation department is in the Carrollton office. It's actually across the street from the courthouse. To me, the logical solution would be to have that registry in the Chancery Clerk's office. That's where they're going to go to do the title search to start with anyway. So if we had it in the one that's issuing the actual ledger, then you're asking people that come to title searches that might drive an additional 20 miles to go to the Carrollton Sanitation office to do the checking. We just get a printout every month, and we have it on file there in the Chancery Clerk's office, which is my office.
And I think that is a fair discussion to have. I think if we put it where it's Chancery or tax, one of those two, and it is a declaration of record, then that kind of solves that. And if you and your board wanted to do that, ideally, we would love to see where, personally, when I do title work, I would love to have a computer there that has access to tax, circuit, garbage, which we have those in a lot of counties. So you can just run your search right then. We're not trying to do an additional burden on anybody, but we've got to find a solution there. And I think that if we did that, we put tax or Chancery, you would have the right to choose to put it in your Chancery office and have it of record there. Yes.
And
yes, sir.
If we're doing it real time, if we're doing it real time in our office, it would be no problem to have it in both places. We can have an icon, we have an icon on our computer in the record room. If the tax collector wants it on his or hers, they'd have the same, so that it's in both,
That's right.
wherever you want to.
Yes, sir.
Charles, you're out here with me. And the biggest question I have, I guess, from the how these current registers that we have, as I understand it, they're not in the name. Could be a tenant, never owned property, and those kind of things where we are needing a registry where that abstract or they look at the sexual index, they can search the name of the property back or something. Oh, so how are we gonna this? Do a parcel number, do the actual fact plan, so that the abstract or attorney gets started this parcel land that I'm trying to secure own title. How do I know it's clear? That is our main goal. And so we gotta have that discussion, how that's important, and how these old registries could be tied in this. This, whatever you call it, be tied to this new registry and tied to an actual parcel plan. We could have that discussion.
All right, so just for clarification, so everybody can hear it online, is the question is, how do you tie that current tax lien or that tax lien when it's recorded to the meets and bounds description? Because you have names, you have addresses, you have all of these things. How do you tie to that meets and bound description? And do you need to use a parcel number? That's the initial question there. Now, Senator Branning's got some follow-up on that, so I'm gonna recognize her first.
I may be late to the party on this, but it was my understanding that earlier in the discussion, we were talking about adding a special assessment through the tax assessor's office, which would tie that automatically to the tax parcel, therefore backing it into your legal description, all those things that we need, instead of having an actual separate book. So if I have misunderstood, somebody straighten me out, but I thought that was going to solve all those issues.
Well, and I think to clear that up, we were talking about continuing to bill and have a registry during the year. But until such time as, let's say, when y'all run your records, Mr. Ladner, about November is when you're going to probably input your information for your tax bills.
Yes, sir.
And as of that date is when you're talking about anything that would be outstanding would be put in as a special assessment.
Yes, sir.
Please address that.
Yes, sir. And the vice chair is right on the proposal that we had was to do a special assessment on the parcel in the tax sale to address your very issue, so that it is indexable, which the tax sale is indexed by the Chancery Clerk's office every year. It's indexable, it's searchable, the whole thing. In our county, you don't get a garbage bill without a parcel number being attached to it. That again, we have the luxury of having a large staff and stuff like that. But I think the register we're talking about is more a list of the ongoing garbage accounts that are in place right now, so that when you're doing the closing, you can check your index, your land records to see what's out there that went to the tax sale. And then you can go check that registry in the office where it's being billed from to see if it's current from January 4th. Just like you can do the utility bill at the water department to make sure that it's made. So I think we're looking at a combination of things here. The tax sale portion of it being to handle the delinquencies, the major delinquencies, the ones that would be inside of the year, that would be before that November you're talking about, that would, when a closing took place on June, would be you come into my office, the Hancock County Tax Collector's office, and pull up Jimmy Ladner at number 2 Woods Place and show that he either has paid his garbage bill for 2022 or not. And that's where you would make that adjustment at the closing time. That's the way.
But you would still have to, I guess some of the question here is, even with that registry, there was going to be a new requirement for all counties to put the actual parcel number on that registry. Is that kind of the route we're going to have to go?
I think that would necessarily be required, because when that county chose to do that special assessment, they're going to do that research then to make sure where that garbage bill should be tied to.
But I think Mr. Greer's question is, up until that assessment takes place, you have a name or you have a potential address, and that person or that name may not attach to the property. So it may be a renter, or it may be, cousin Eddie's friend is living there, whatever it may be. But that is an impossibility to search unless you know all the renters on that property. So I guess the question is, do we remedy that by requiring the parcel number to be attached for the research before? And I think Senator Super may have a follow-up question on that as well. So if you want to answer that, and then Senator Super.
It certainly could be remedied by adding the parcel number to any account that was open. It certainly could be remedied that. I think it would be problematic with some of the agencies that are doing the billing now, not having access to the records to come back and catch that up. You know, this is one of those things that, you know, if we were having this discussion in 1993, when this went into effect and had the foresight of the 30 years, we could have addressed that. You know, we took that action in Hancock County and it helps immensely. I mean, because it's hard for people to deny it's theirs when you produce their parcel number and your bill showing this is when you started. So I think going forward, and if we was to make this change to put any that was going to be used through the tax sale, would require that the parcel numbers be added at that then for new accounts, because that's where you're going forward. That would put it on the people that are doing the billing, that they can generate what you're talking about. But to try to require it now, particularly in some small jurisdictions that may have 3,000 or 4,000 garbage accounts, which don't sound like a lot, but again, if you're doing it with 2 or 3 people, it's overwhelming. You know, so I think this could be done. I think if we, you know, I don't think we can answer all the questions in here today, but I think with the people sitting in this room, and which to be completely candid, my 24 years in office, having all these people, even 85% agreeing on the same thing is pretty unique. So I think that we can get this done through the tax sale and work out the kinks that you're talking about while we're doing it. It's
Senator Super, you want to follow up with him?
Yeah, and I agree. And I appreciate you coming down here today, or up here. Down here for me, but the issue with the parcel number is we have lots of parcels that might have 10 or 15 different residences on one parcel. It might have 10, 15 garbage accounts on that one parcel. So you have, I guess, one doesn't pay and the other 14 do. Are you still gonna assess the parcel number? And I think that's still a good route, but I just.
And if I may.
Sure. Please address.
In most cases, when you have that situation, because we've had that, you're looking at some multifamily use, like a trailer park or something like that. And the statute clearly says the generator or the property owner is responsible for the bill. So in that case, I would submit if a person has 14 rental manufactured homes on his place, he ought to do one of 2 things. He ought to make sure that those 14 people are paying their garbage bill, or he should be responsible for the garbage bill. And that's where the parcel, and I can tell you by example, my dad had one of those trailer parks when I took office, it cost him $1,200. I mean, so it will work when you do it that way as well.
Well, and I'm from a very rural county, and you know, we have lots of families that have 2 or 3 houses, and they'll rent them out to family members, stuff like that. So
Biggest problem, grandma let little Johnny put a trailer in his house, and now he's got a garbage bill.
right, that's exactly what I was getting at.
And I get it, we would do that, and I can tell you, when we started holding tags for garbage bills, grandma lived out in the rural area of the county, little Johnny was living inside Bay St. Louis. He was registering his tag out at grandma's house to get away from the high millage inside the city. He don't do that anymore. He moved because I live in Bay St. Louis. I shouldn't be responsible for grandma's tag. My grandma's garbage bill, well, that's where you tag for it. So pay your grandma's bill, move your residency where it's supposed to be in Bay St. Louis, and we'll give you a tag. And it's work. So I think those are the issues that I think can be worked out. And that's typically what you're dealing with there. You know, either a family issue or a multi-family situation where it's a trailer park, or in some places even apartments. I mean, you know, because apartments can have individual garbage bills as well, and they do in some counties. So, but it's still the owner of that property that's ultimately responsible, because he's letting those people stay on his place. He knows they're generating the garbage. He should be making sure that they're paying it, or he should be responsible for it if the statute clearly says.
I think Mr. Havens, that's a follow-up. I saw him.
Charles,
You want to let Mr. Greer?
Just real quick, I want to make sure I understand. In ability to have a lien against real property, right, that's the problem. And under this solution, the only way to protect that lien, under the amendment statute, the only way to protect that lien is to property. This special exception. So that's how the statute is. Yes, sir.
And to require that a registry actually be held in every county in one of those two offices. And at the end of that, or November, whenever it is you submit your time, and of course, we would have to require it go to the board of supervisors, certify, then it goes on the special assessment thing, to go through the statutory process. But we are saying that we would require there'll be a list in every county for you to go to. And then in November, if it still isn't paid, then they're gonna put it on your tax bill. So does that clear some of yours up, Senator? All right, who else had some responses, discussion?
And at
Yes.
that point, as Mr. Ladner said, we will have to come up with a parcel. In our case, we don't. I've got 15,500 customers. They are not tied to a parcel number. They're John Doe and address. And so, but before we send them to the tax sale, we're gonna have to find and I don't know how many of our 15,500 we'd send, but if we send 1,000 of them, we're gonna have those 1,000 parcel numbers in order to do it, because that's the only way to run it through the sale. So we're gonna have to generate that.
And if I may to add on to that, that's again, real similar to what we do with cleanup situations and condemnations. A lot of times when we get that order from the city council or the board of supervisor, not as much the board because I prepare to be completely candid. With the city councils, a lot of times that is tied to the address, not the parcel number, and we have to go do the research and get the parcel number for the city. So that's not an unusual situation that Lee County is in.
And I think there's some more discussion from land title saying, why couldn't we just go ahead and when they establish that account, put that parcel number and maybe put a 2 or a 3 year window out there when it's required to be on your registry? And I know that's putting more work on everybody. That's what's going to get me in trouble in the session whenever I say you've got to do this. But if we give you 2 or 3 years or whatever it may be out there, I think it's going to, at the end of the day, solve 2 problems. Number one, if they don't pay it in November, you've already got your parcel number. Number 2, it provides that notice and that access for your people that are doing the title work back there. And the worst thing we can do is cause more headache for a home buyer that's trying to move forward and come back in your community, in your county. Because that's what we've got to not do, is provide hindrances. Mr. Haymans, you mentioned something to me.
Just last few comments on just the devil's in the details. The statute allows for the board of supervisors to establish procedures for the manner in which notice shall be given and the contents of the notice. I think we should make that more uniform across the state and actually establish that not only the owner and generator should get notice similar to a tax sale, where it's, your 3 forms of notice, it's all done simultaneously. We need to make sure that the notice is actually given to them. 2, if we could preclude the third-party purchasers without notice and make it clear to the tax assessors that they cannot be prevented from getting a car tag, then that would clean a lot of this gap issue up that we've been talking about. Senator Branning and Charles mentioned, what do we do about the tenants? By putting some sort of statute of limitation, 3-5 years, putting some sort of sunset, like you mentioned, a year, 18 months out when those need to be filed. I think that'll it'll clean that up going forward. But if there's a tenant that didn't pay their garbage bill in 16, and the property was sold in 22, we need to make sure that the 2022 forward owner doesn't have any liability for that.
Well, I think that's the intent of requiring that registry to be implemented. I do want to say this, and the Attorney General's office is here, and I will ask them to kind of look into that before we do it. As far as the statute of limitations, I think you're gonna, you may face some constitutional challenge there. I don't want to get off in that.
Sure.
At the end of the day, what it may be, the discussion and the requirement to file that registry by January 1st of 2024 may at that point cut off your ability to make it a lien.
Yep.
But you cannot sit there and forgive as a personal debt against that for the state for a service rendered by a county.
Yeah, we just
So I
need to
think that's
protect,
what we're gonna get into.
we can protect the purchasers. I think
We can protect the purchaser by keeping it from being that property lien. And we've got an attorney here.
Speaking to that a little bit, Mr. Chairman, Senate Bill 2457, it included municipality too, and it shouldn't. It's just gonna be county. But it had some language about, after a certain point, you can't file it as a lien, but you can still pursue it against the generator of the garbage.
And I think that may be the middle ground that we've got to go to, ladies and gentlemen, as we move forward with this. Additional comments, questions? Committee, any questions from anybody? Even if they didn't talk. Clark is over there. You can ask him questions. Look, I appreciate everybody coming together. If there's no other questions or comments, I do encourage you, you've made a consensus among your associations. You've started a dialogue. Let's get this done with so we don't have 3 years of additional bills coming up and dealing with this after the next year. I think that we've all found some good middle ground, and I think we can make this work. So I look forward to working with you. Additionally, do remember that you have a very, very short window in which to request legislation this year. So if you want to get together with your associations and get a draft and get it to us before the end of the year, that would be great. As we come in and we have less than a week to put a request in for a bill. And then that bill is going to require you to talk to your members and to let them know this is not going to be bad. And that this is to try to fix that problem where we have $2 million due in counties. And that $2 million could go a long way to the bridges that are out in your county. So I request that of you. I will work with you. All these senators, representatives, Senator Andrew Turner Ford, and all the others will work with you to find a solution. If you will work with us, we will work with you. If you decide that we're not going to do this year, I'm going to forget about it and move on, and we'll have the same issue next year. So let's get her done in 2023, and we can be back. So other than that, if there's no other questions, we'll call this dismissed. Thank you for coming.
Yes.